Imagine walking along a railroad track. You slip, your foot gets stuck. A train is coming. You scream, but it's too late. Are you protected by law? That's the question at the heart of Sheehan versus St. Paul and Duluth Ry Co. A 19th century case that still shapes how courts define duty to trespassers. Sheehan, the plaintiff, was walking on the tracks of the St. Paul and Duluth Railway without permission. His foot slipped and became lodged in the rail. As a train approached, Sheehan struggled to free himself. The train crew didn't see him until it was too late. The train ran over his foot, causing serious injury. The crew attempted to stop the train but couldn't do so in time. Sheehan sued the railway company, arguing they failed to exercise proper care. The trial court directed a verdict for the railway, and Sheehan appealed. Does a railroad company owe a duty of care to a trespasser injured on its tracks, and when does that duty arise? The courts found that railroads owe a duty of reasonable care to trespassers only after they are discovered. But prior to discovery, no duty to anticipate or protect against trespassers exists. Sheehan was a trespasser. The crew didn't see him until it was too late. Once discovered, they made reasonable efforts to stop the train. No evidence showed wanton or reckless conduct. The Seventh Circuit affirmed the verdict for the railway. The company fulfilled its duty once Sheehan was discovered. No liability for injuries caused before that moment. The court distinguished between two types of duty. A positive duty of constant care at public crossings, where people are expected, and a negative duty to avoid wanton harm to trespassers, which arises only after discovery. For law students, Sheehan versus St. Paul and Duluth is a foundational case in tort law. It clarifies the limits of landowner liability and the moment when duty begins. For everyday citizens, it's a reminder: trespassing changes the legal equation. Protection under negligence law depends on visibility, foreseeability, and timing. The court also balanced public safety with operational feasibility. Requiring railroads to anticipate trespassers at every point would impose an unreasonable burden. The duty to act begins when danger is visible, not when it's merely possible. Sheehan v. St. Paul and Duluth Ry Co. teaches us that duty isn't automatic, it's situational. For more case briefs and creative law study tools, subscribe to 99 Rights online. Let's make the law make sense together.